Got a little time to do Amazon.com versus Barnes & Noble. After the State Street Bank versus Signature Financial, the floodgates were open. The dot-com boom was booming along, and Amazon.com got a patent on its one-click computer-based method for single-action ordering of items in a client-based environment. This is one of the figures which I think I've quoted in the outline from the Amazon.com patent. I think Jeff Bezos was one of the joint inventors. And we talked a little bit about a claim in a patent application. There's got to be some objective criteria to determine infringement of a patent. And the objective criteria is a claim at the end of the patent. Now, before we get there, I just wanted to show you a little bit of one of the flow diagrams. And if you notice from the picture, there is a reference to a set client customer mapping. And in 303, set single action ordering for client. That's the Amazon.com one-click function. And then that enables a user to do a checkout using one click. Well, then they got this claim, which also defined the click function. Let me see if I can get this here. And this is the sequence of the system for the one-click checkout function. You'll notice in the fourth line there's a reference to a single action ordering component. That's the heart of the invention. Single action, one click. That's what they promoted. That's what they started to become famous for. And Barnes & Noble, they accused Barnes & Noble of this single action one-click function checkout. And they sued Barnes & Noble in federal court in Seattle. And they sought a preliminary injunction. Recall that the preliminary injunction is when the plaintiff says the defendant is going to trash my patent or copyright at the beginning of the case. I need to get an injunction now, Your Honor, because we have to stop the defendant from infringing, because even if I can get a judgment a year or two from now, my intellectual will be worthless. So they did have a hearing. The judge held a hearing. In fact, the witnesses showed up. I don't know if Bezos was one of them who testified, and they had experts on either side, and she listened to the testimony. Now, in an infringement case, the plaintiff, the patent owner, has the burden of proving two things. Number one, it owns the patent, and number two, that the defendant infringes the patent. Now, there was no question here that Amazon owned the patent. What's the test of infringement? Amazon said that all of the elements of at least one of its claims are found in the Barnes & Noble invention, the Barnes & Noble structure. And Barnes & Noble said they try to make an argument that they don't infringe, that there's some elements in this claim that they don't have, but their argument wasn't all that strong. But the defendant does have another defense. The defendant contends that the invention doesn't meet the test of novelty and non-obviousness. That if a patent meets the test of novelty and non-obviousness, the examiner will issue the patent. The patent is presumptively valid, but not conclusively valid. Now, what that means is that a defendant in an infringement suit could try to persuade the court to invalidate the patent based on some prior patents or publications which the examiner may not have examined. And in fact, Barnes & Noble told the court there was a prior invention a few years beforehand, the CompuServe system, and it identifies the invention as a one-click function. And the court listened to the argument, and the court said that the CompuServe system would not be anticipatory of the Amazon.com invention because it doesn't have, the court says, the system does not identify an item that a user could order with a single action. That was what her was after she heard all the testimony. And on that basis, she rejected Barnes & Noble's defense that the invention lacked novelty and that the invention was obvious. And so she granted a preliminary injunction. Interesting that when a preliminary injunction is granted, the plaintiff has to post a bond. So if the defendant can prove later on after trial that the defendant should have won, the defendant is entitled to collect on the bond because the defendant has now been shut out of the market during the period of the injunction. And she made the defendant, she made the plaintiff, Amazon.com, post a $10 million bond. Well, by this time, Barnes & Noble, anyway, though, the judge did make an interesting statement, which is rather interesting in cases like this. When the judge grants the plaintiff a preliminary injunction, the defendant always would like to tell the judge, Judge, if I change this or if I change that, can I get around the injunction? Now, the judge doesn't have to answer that question. The only thing before her is whether she should grant a preliminary injunction. And she has to make that decision. And then under the federal rules of civil procedure, she must give reasons. So she did make her decision. She did give her reasons. But then she offered Barnes & Noble a way of sort of getting around it. She says, all Barnes & Noble has to do to avoid the injunction is simply require users to take an additional action to confirm orders placed. Yeah, I mean, so, Barnes & Noble guys, hey guys, 1 click, 2 clicks, fucking deal. Just add another click, So anyway, though, Barnes & Noble decided that they didn't like her click and opinion, they're going to appeal. So they did. Actually, it was a smart decision because they went up to the Court of Appeals. And they got the Court of Appeals for the Federal Circuit to reverse. And they said that the Court of Appeals saw the CompuServe patent, the CompuServe invention, excuse me, it wasn't patented, it was an invention. They saw it differently. And the Court of Appeals reversed. They said because there is a question whether or not Amazon.com will prevail at trial. That is, the Court of Appeals said that the district court failed to recognize the substantial question of invalidity raised by Barnes & Noble in citing the CompuServe reference, in that the system appears to have used a single action ordering technology. So here the Court of Appeals is saying, well, we see this CompuServe thing differently from the trial court. We saw it one way. The 3 judges in the Court of Appeals saw it a different way. So they reversed the order granting the preliminary injunction. They sent it back to the trial court. Now, the case could have gone to trial. In fact, after trial, the trial judge might have come up with the same opinion that she had at the preliminary injunction hearing. But we don't know that because the case went back. Now, keep in mind, at this stage of the proceedings, Barnes & Noble has a lot of leverage because Amazon.com posted that $10 million bond for the injunction. And at that time, I don't know if they were making any money. I heard now they've moved into the black. They're starting to make some money. So if Barnes & Noble had gone to trial, they would and won the case. Well, actually, they could have collected on the bond even without having to go to trial. But after going to trial, though, if they had won the case, they might have kept the $10 million and possibly been able to use the single-click action function.